prior LaborSpeak videos, we have discussed the rapidly changing restrictive covenant landscape. In this video, we turn our attention to Delaware. In the past, Delaware courts have been inconsistent in their enforcement of restrictive covenants, but two recent cases show that Delaware may be pushing back on the ability of employers to use non-competes. In one case from last October, Kodiak Building Partners LLC v. Adams, a Delaware LLC sought to enforce a restrictive covenant agreement against a former employee and stockholder where the agreement was entered into in this connection with the sale of a business. Generally, courts are usually more willing to enforce restrictive covenants agreed to in the sale of business context than in the employment context. But in this case, the court held that the restrictive covenants were too broad as they extended to all the companies the LLC owned, rather than only those connected to the individual. Another case decided earlier this month, Ainsley v. Cantor Fitzgerald LP, involved 6 former Cantor Fitzgerald partners who entered into Cantor's limited partnership agreement, which contained a 1-year global non-compete, a 2-year global non-solicit, and a forfeiture for competition provision that conditioned payments from each partner's capital account and other payments related to the partnership interests on the partner not breaching non-compete and non-solicit restrictions for 4 years. All of the former partners in that lawsuit voluntarily withdrew from the partnership and went to work for a competing business. As a result, Cantor refused to pay them the conditioned payments. The court held that the non-compete and non-solicit provisions were unenforceable. First, because they were too geographically broad and long. Second, because they sought to prohibit actions taken against not just Cantor, but any of Cantor's affiliated entities. And third, because it was solely up to the managing general partner to determine whether a partner had breached a restrictive covenant. As a result, the court also found that Cantor could not condition payments on compliance with these provisions. Further, in a somewhat unusual move, the court separately reviewed the reasonableness of the forfeiture provisions, finding them problematic because they withheld amounts were not connected to any loss Cantor suffered as a result of the competition. The amounts would have been withheld regardless of the reason for termination, and the provision was included as part of an agreement that the partners could not negotiate. While many new state laws have focused their efforts on protecting non-executives and non-owners from restrictive covenants, these two decisions protected high-level employees with an ownership interest. In these cases, the court struck down 2 types of restrictive covenants that we are used to seeing courts readily enforce: a non-compete in the sale of business context and a forfeiture for competition provision. These decisions further demonstrate the wave mounting against restrictive covenants across the country. Feel free to contact a member of our team if you have questions about these or any other issues relating to restrictive covenants.